Commission. Establishment of the Commission. The National Human Rights Commission is a statutory and not a constitutional body. It was established in 1993 under legislation enacted by the Parliament, namely, the Protection of Human Rights Act, 1993-1. This act was amended in 2006. The Commission is the watchdog of human rights in the country, that is, the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants to and enforceable by courts in India. The specific objectives of the establishment of the Commission are three: A. To strengthen the institutional arrangements through which human rights issues could be addressed in their entirety in a more focused manner. B. To look into allegations of excesses independently of the government in a manner that would underline the government's commitment to protect human rights. And C. To complement and strengthen the efforts that have already been made in this direction. Composition of the Commission. The Commission is a multi-member body consisting of a chairman and 4 members. The chairman should be a retired Chief Justice of India, and members should be serving or retired judges of the Supreme Court, the serving or retired Chief Justice of a High Court, and 2 persons having knowledge or practical experience with respect to human rights. In addition to these full-time members, the Commission also has 4 ex officio members: the Chairman of the National Commission for Minorities, the National Commission for SCS, the National Commission for STS, and the National Commission for Women. The Chairman and members are appointed by the President on the recommendations of a 6-member committee consisting of the Prime Minister as its head, the Speaker of the Lok Sabha, the Deputy Chairman of the Rajya Sabha, leaders of the opposition in both the Houses of Parliament and the Central, Home Minister. Further, the sitting judge of the Supreme Court or a sitting Chief Justice of a High Court can be appointed only after consultation with the Chief Justice of India. The chairman and members hold office for a term of 5 years or until they attain the age of 70 years, whichever is earlier. After their tenure, the chairman and members are not eligible for further employment under the central or a state government. The President can remove the chairman or any member from the office under the following circumstances: A. If he is adjudged and insolvent, or B. If he engages, during his term of office, in any paid employment outside the duties of his office, or C. If he is unfit to continue in office by reason of infirmity of mind or body, or D. If he is of unsound mind and stands so declared by a competent court, or E. If he is convicted and sentenced to imprisonment for an offense. In addition to these, the President can also remove the chairman or any member on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the President can remove the chairman or a member. The salaries, allowances and other conditions of service of the chairman or a member are determined by the central government, but they cannot be varied to his disadvantage after his appointment. All the above provisions are aimed at securing autonomy, independence, and impartiality in the functioning of the Commission. Functions of the Commission. The functions of the Commission are: A. To inquire into any violation of human rights or negligence in the prevention of such violation by a public servant, either ex suo to or on a petition presented to it or on an order of a court. B. To intervene in any proceeding involving allegation of violation of human rights pending before a court. C. To visit jails and detention places to study the living conditions of inmates and make recommendations thereon. D. To review the constitutional and other legal safeguards for the protection of human rights and recommend measures for their effective implementation. Each reviewed the factors including acts of terrorism that inhibit the enjoyment of human rights and recommend remedial measures. F. To study treaties and other international instruments on human rights and make recommendations for their effective implementation. G. To undertake and promote research in the field of human rights. H. To spread human rights literacy among the people and promote awareness of the safeguards available for the protection of these rights. I. To encourage the efforts of non-governmental organizations and NGOs working in the field of human rights. J. To undertake such other functions as it may consider necessary for the promotion of human rights. Working of the Commission. The Commission's headquarters is at Delhi, and it can also establish offices at other places in India. It is vested with the power to regulate its own procedure. It has all the powers of a civil court, and its proceedings have a judicial character. It may call for information or report from the central and state governments or any other authority subordinate thereto. The Commission has its own nucleus of investigating staff for investigation into complaints of human rights violations. Besides, it is empowered to utilize the services of any officer or investigation agency of the central government or any state government for the purpose. It has also established effective cooperation with the NGOs with first-hand information about human rights violations. The Commission is not empowered to inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. In other words, it can't look into a matter within 1 year of its occurrence. 4. The Commission may take any of the following steps during or upon the completion of an inquiry. A. It may recommend to the concerned government or authority to make payment of compensation or damages to the victim. B. It may recommend to the concerned government or authority the initiation of proceedings for prosecution or any other action against the guilty public servant. C. It may recommend to the concerned government or authority for the grant of immediate interim relief to the victim. D. It may approach the Supreme Court or the High Court concerned for the necessary directions, orders, or writs. Role of the Commission. From the above, it is clear that the functions of the Commission are mainly recommendatory in nature. It has no power to punish the violators of human rights, nor to award any relief, including monetary relief, to the victim. Notably, its recommendations are not binding on the concerned government or authority. But it should be informed about the action taken on its recommendations within 1 month. In this context, the former member of the Commission observed 5. The government cannot wash away the recommendations made by the Commission. The Commission's role may be recommendatory, advisory, yet the government considers the cases forwarded by it. It is, therefore, improper to say that the Commission is powerless. It enjoys great material authority, and no government can ignore its recommendation. Moreover, the Commission has limited role, powers, and jurisdiction with respect to the violation of human rights by the members of the armed forces. 6. In this sphere, the Commission may seek a report from the central government and make its recommendations. The central government should inform the Commission of the action taken on the recommendations within 3 months. The Commission submits its annual or special reports to the central government and to the state government concerned. These reports are laid before the respective legislatures, along with a memorandum of action taken on the recommendations of the Commission and the reasons for non-acceptance of any of such recommendations. Performance of the Commission. The various human rights issues taken up by the Commission are as follows. 1. Abolition of bonded labor. 2. Functioning of the mental hospitals at Ranchi, Agra, and Gwalior. 3. Functioning of the Government Protective Home Women. Agra. 4. Issues concerning right to food. 5. Review of the Child Marriage Restraint Act, 1929 6. Protocols to the Convention on the Rights of the Child 7. Preventing Employment of Children by Government Servants. Amendment of Service Rules 8. Abolition of Child Labor 9. Guidebook for the Media on Sexual Violence Against Children 10. Trafficking in Women and Children, Manual for the Judiciary for Gender Sensitization 11. Sensitization Program on Prevention of Sex Tourism and Trafficking 12. Maternal Anemia and Human Rights 13. Rehabilitation of Destitute Women in Redivan 14. Combating Sexual Harassment of Women at the Workplace 15. Harassment of Women Passengers in Trains 16. Abolition of Manual Scavenging 17. Dalis issues including atrocities perpetrated on them 18. Problems faced by denotified and nomadic tribes 19. Rights of the disabled persons 20. Issues related to right to health 21. Rights of persons affected by HIV/AIDS 22. Relief work for the victims of 1999 Morris Cyclone 23. Monitoring of relief measures undertaken after Gujarat earthquake 2001-24. District Complaints Authority 25. Population Policy, Development and Human Rights 26. Review of statutes, including Terrorist and Disruptive Activities Act, and Draft Prevention of Terrorism Bill, 2027. Protection of Human Rights in Areas of Insurgency and Terrorism 28. Guidelines to check misuse of the power of arrest by the police 29. Setting up of human rights cells in the state/city police headquarters 30. Steps to check custodial deaths, rape and torture 31. Accession to the Convention Against Torture 32. Discussion on adoption of a refugee law for the country 33. Systemic reforms of police, prisons and other centers of detention 34. Review of laws, implementation of treaties, and the international instruments on human rights 35. Promotion of human rights literacy and awareness in the educational system 36. Human rights training for the armed forces and police, public authorities and civil society. Human Rights Amendment Act, 2006. The Parliament has passed the Protection of Human Rights Amendment Act, 2006. The main amendments carried out in the Protection of Human Rights Act, 1993, relate to the following issues. 1. Reducing the number of members of state human rights commissions, SHRCs, from 5 to 2. Changing the eligibility condition for appointment of members of SHRCs 3. Strengthening the investigative machinery available with human rights commissions 4. Empowering the commissions to recommend award of compensation, etc., even during the course of inquiry 5. Empowering the NHRC to undertake visits to jails even without intimation to the state governments 6. Strengthening the procedure for recording of evidence of witnesses 7. Clarifying that the chairpersons of NHRC and SHRCs are distinct from the members of the respective commission 8. Enabling the NHRC to transfer complaints received by it to the concerned SHRC 9. Enabling the chairperson and members of the NHRC to address their resignations in writing to the President and the chairperson and members of the SHRCs to the Governor of the state concerned 10. Clarifying that the absence of any member in the selection committee for selection of the chairperson and members of the NHRC or the SHRCs will not vitiate the decisions taken by such committees 11. providing that the chairperson of the National Commission for the Scheduled Castes and the chairperson of the National Commission for the Scheduled Tribes shall be deemed to be members of the NHRC 12. Enabling the central government to notify future international covenants and conventions to which the Act would be applicable. Notes and references. 1. The President promulgated the Protection of Human Rights Ordinance on September 28, 1993. Subsequently, the Protection of Human Rights Bill, 1993, was passed by both the Houses of Parliament and received the assent of the President on January 8, 1994. The Act came into force with retrospective effect from September 28, 1993. 2. International covenants means the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights adopted by the General Assembly of the United Nations on December 16, 1966, and such other covenant or convention adopted by the General Assembly of the UN as the central government may specify. The Indian government acceded to these two international covenants on April 10, 1979. 3. T.K. Thommen, Human Rights Commission, Cochin University Law Review, Volume XVII, NOS 1 and 2, March-June 1993, page 67 to 68. 4. The Hamadi Committee set up by the Commission recommended that the Commission should be empowered to inquire into any matter after the expiry of 1 year, if there is sufficient reason for not filing the complaint within the said period. 5. Justice V.S. Malinet, Role of Human Rights Commission, Human Rights in India, Problems and Perspectives, B.T. Singh Sehgal Education D. Publications, 1995, page 17 to 20. 6. Under the Act, Armed Forces means the naval, military and air forces and includes any other armed forces of the Union. The Hamadi Committee set up by the Commission recommended that the definition of the armed forces should be changed in a way that it includes only Navy, Army and Air Force, not para military forces.